The ECOM marketplace Confluence was held in New Delhi recently to act as the first platform for legal experts as well as business leaders to converge and deliberate upon key issues such as the insurgence of e-commerce and the modalities involved in handling this revolution. The event was organized by Legal League Consulting, and the theme of the event centered on the keywords think, manage and lead. The event started off with a welcome speech by Bhitika Anand, founder and CEO of Legal League Consulting.
Legal League's Consulting's journey for last 5 years has been full of excitement, challenges, passion, innovation, and commitment. With the support from all our patrons and well-wishers, we are moving towards the path of fulfillment of our vision. Our mission is to deliver vital insight, strategic advice, and execution-level support to the legal profession and to ensure competitive advantage and success. We aim to collaborate with all of you to make it happen. While a lot has been achieved by us, I really believe that this is just the beginning and sky is the limit. Thank you.
The day-long event covered all major aspects of e-commerce revolution and focused on the legal framework governing the sector. Legal stalwarts like Cyril Shroff, Ajay Pahel and Gaurav Dani shared their insights in the inaugural session.
I think the rise of e-commerce is really a symptom of this larger disruption and change that is taking place in the world because of so many factors. It's again an internet-based revolution that has taken place. For the factor, if you now think back in terms of why is e-commerce such a big phenomenon, and we're still at the early stage of it, we can keep marveling at how much the industry has achieved, but I believe it's achieved only about 10 to 15% of its true potential. The balance of the thing it has done is it has changed the balance of power and put it back in the hands of the ones who really need to have the power, namely the consumer. And they provided that phenomenally intelligent interface. The second thing which I want to talk about now, considering again the legal overtone of this conference, is the disconnect between our legal and policy framework and the digital world. Taxi hailing, Uber is a classic example. The time when the regulations were framed and the laws were made, nobody had even imagined the possibility of such an application that it could really provide this intermediation between the user and the taxi driver in such an intelligent way. And the law never contemplated it. And a lot of the quarrels and the fights that you see, including in this city, are based around this fundamental disconnect, that the fact that the real world and the technology world has moved so far ahead. Things like data privacy, electronic fraud, implications on competition law. I think competition law is just about coming to even acknowledge the fact that there are so many issues resulting in this. I think technology will keep moving. I think Moore's law may get crushed even faster when you sort of apply it to this world. And the mobile revolution will enable that. I think that there has to be a new dialogue on policy and regulation. In terms of all the traditional models of whether it's providing finance, whether it's movement of goods and services, whether it's, and then the sort of tertiary implications on things like competition law, labor, data privacy, the works, dispute resolution. How are disputes going to be solved in this electronic world? Are they going to be solved in the electronic world, or are they going to be solved in the, if I can call it, the real world? Are our courts equipped to even deal with issues of this and what emerges from this new era of how business is done? I think these are questions which are going to engage all of us for a very long time to come. It's exciting to be living through this because I was not even born when the Industrial Revolution happened. I'm happy to be part of the second industrial revolution or the computer revolution, whatever you call it, because this is a time when the fundamental nature of humanity is and how the globe does business is being changed. And I think all of us can make a difference. Thank you very much.
Just dealing with the sector, I think there's no question about the fact that the sector has been, the growth of the sector has been a very important phenomenon for the world, for the emerging markets. India is not an exception. Now, obviously, because of that, it also has a lot riding on it. And on the flip side, the e-travel business put travel agents out of business by and large, but that was a small constituent still of business folks. Whereas e-retail at least is suggested to threaten very much the brick and mortar businesses, and particularly small shopkeepers feel threatened by this, and there's bound to be a reaction. The risk of this impacting a wider constituent of relevant people can also push the regulators to consider the need to rethink policies around the models that exist, and to try possibly and limit or restrict the offerings that are currently legitimately offered on these platforms, with a view to balance the sort of needs of others who believe they are being unfairly treated in this entire this phenomenon. I think that's an important thing for the industry to reflect on. We also have to recognize, as many reports have said, that almost $20 billion of cash is going to be needed to bring stability to this industry between now and 2020. And given the relative scarcity of capital in India, investable capital, we have to assume a large portion of this is going to come from outside. Therefore, any regulatory change which either impedes the model, restricts the model, or can adversely impact these flows will have not only an adverse impact on the e-commerce sector, but can have a very, very adverse exponential knock-on effect on the entire ecosystem that has been created around it. And that is why this need to reflect is important. Thank you very much.
The concept of e-commerce has existed for a long time, but we've just seen sort of a frenzy, as Bitika calls it, in the last 5 to 7 years. And that's largely because of the penetration of the mobile-based technologies and the advent of smartphones. So that has made it very accessible, and that's the reason why we've seen a tremendous growth in the last few years. What is most unique about this industry is that the technology has made the typical entry barriers redundant and given the same level playing field to everybody in terms of entry. So things like experience, knowledge, age don't really matter. It's all about innovation. It's all about how you can execute, how well you can execute. The forces of technology and competition also changed the innovation environment dramatically. The days of relying on single sustainable competitive advantage are over. Companies must focus instead on spotting sources for advantage, exploiting them fast, and moving on very quickly. Similarly, from a lawyer's perspective, it is very important that the advice we give is tailor-made to the business model, and also that the investment structures we create are robust enough to ensure scalability, especially when you're advising a company at the seed round or the angel round. It is very important to look through the structure as if the company is going to do an IPO. So that's where I find it's very important from lawyers to give proper attention to those companies at the start level. And thank you again, Legal League, for bringing us together.
The Confluence saw over 150 key stakeholders from the e-commerce industry, including Snapdeal, Flipkart, and Amazon India, who shared their business experiences in the foundation session.
It all started with investors when they wanted to invest into e-commerce companies, saying that, well, let's make something to make people habitual of going on internet and trying to buy something, and it started through classified sites and it went into e-commerce, and now it's been something else. Now it is the stage, because we all see in the newspapers about the GMV, what's the GMV of Flipkart, Amazon, and Snapdeal and all. But if you go to the investors now, if you actually want the next multi-billion-dollar valuation, they're not talking about the GMV, or they're not talking about the number of users. The one thing which they ask, what is the problem you are solving? I think that's the level of maturity of e-commerce or consumer internet, I would say, that India has reached to. So I think India is at a stage where regulators should quickly move on from this euphoria of e-commerce. They should quickly take a stand. Whether they want to regulate, okay, come and regulate. Let's talk to the industry players and let's make some kind of business-friendly regulation. Let's move on and think about that how the government can work with the industry to take this consumer internet to the next level. Let's have some flexible land laws. Let's make sure that, we people get big land to make sure that there are warehouses, goods are stocked in a proper way so that you as consumer can get the good in safe and a convenient way in shortest possible time. Let's make some flexible law to make sure that we have drones available in the company so that this logistics problem gets solved, right? Let's make something so that the bandwidth is available at a cheaper cost, the call drops are out. That will create the good ecosystem for the e-commerce. So that's where I would end, and I wish you all the best for this conference, and I am sure that you will learn a lot. Thank you.
Morning, everyone. 2-3 things. I think so. One, I think the regulatory framework. More is from the point of view that most people don't understand what exactly these e-commerce companies are doing, whether we are really the marketplace or we are the traders ourselves or we are what sort of situations. So one example which I learned out over there when this was being discussed, I said that perhaps we are one good platform of, let us say, Rajinder Sharma and Sons operating in Gurgaon. And today means rather than catering my small community in and around MG Road where I stay, I can use this media to spread my goods and my materials which I intend to sell to all across the country. So you'll be surprised to see that a product which is reaching Kerala would be a product from Chandigarh. And by a trader selling in Chandigarh, and he's able to sell his product out in Kerala, out over there. And we had a live example while trying to show this to the VAT officers out over there. So that mindset or change in the regulatory thought process is very, very important to understand and see. Second, which we learned out over there was that perhaps your capability is not being, or your potential to invest in a state is not being seen by the state government as is being done by a brick and mortar manufacturing industry. So why we are not utilizing, or why the government is not understanding the potential of these investments coming in those form in trying to improve that, and the bargaining power which e-commerce industry should have and should be taking for the purpose of saying to the state government, hey, don't discriminate us. We are not the stepchild, or we are not the young babies who are trying to play a video game through our internet. We are also a hardcore industry which is moving into trying to put those sort of feelings into the, or investments into the system out over there. Thank you very much.
So when I joined Amazon, the first thing that we had to realize is that, what is the model that we need to adopt to be able to operate here? So what we really saw in the last 4 years that we've been here, given that restriction, led to a lot of innovation. And I think that's the opportunity that you have to see in a regulated market. And a number of innovations that in terms of how we have used Kirana stores, how we have worked with our sellers, how we empowered sellers to use our platform, have been great learnings that we now will transpose to other parts of the world in Amazon. That kind of logically flows into the second situation, that, and what we faced a lot in India, that you cannot wait for the regulations to clear up and then start your business. I think that would not have worked. A lot of companies have waited and are still waiting. And that's not what you would like to do. You have to work with what you have. And that was a key learning in our case. With that, I'll kind of conclude my remarks. So thank you very much.
Being a recent phenomenon, the e-commerce sector faces a different challenge, that of legal validity of e-commerce transactions. And Anubhav Mehta, legal counsel at commercial bank Standard Chartered Bank, gave an inside view to this particular aspect.
Legal validity of e-commerce transactions, the big questions being faced by all e-commerce companies, banks. I'm representing Standard Chartered Bank here. The very fact that the Information Technology Act came about and started recognizing digital signatures, later on went on to define what is an electronic signature, which is slightly wider meaning. is, in a way, the legislature is recognizing that yes, online transactions do happen and they need to be recognized under law. Whether sufficient progress had been made in that respect is a question we still don't know the answer to that. I mean, obviously I feel sufficient progress has not been made. Let's see, how do we authenticate these transactions? This is where the difference actually lies. Now, the courts in India have at various points of time categorically held that identifying a signature match or identifying a thumb impression match is an exact science. There is no scope for variation. It's 100% exact science. Is there such recognition for any of these? Let's see. Card and PIN, probably the oldest mechanism of widespread usage of electronic transactions, right? User ID and password. Registered number, one-time password. This is a new thing in fashion. But still, there is no legal recognition of this. The only thing which is recognized is digital signature. Is it really certain that a digital signature is always under the control of the signatory? Is it not possible, just like a signature can be forged, that your digital signature token can be lost, misplaced, stolen, right? Nowadays, people are moving to using something called, and it's a form of an electronic signature where someone just signs on the screen of a tab or the screen of a mobile phone. Some of the courier companies have moved to this model, right? But who is to say that yes, the signature was placed here at this point of time, but the data surrounding it has not got changed later? How do you prove that? Do we have actually come up with that level of technology to ensure that this does not happen? Extremely. Now imagine going and proving this before a court of law, how difficult that is going to be. Right? So that's essentially what this is about, that yes, there are things which are recognized in law, but proving them factually, maintaining records and files is such a big question mark right now that every such transaction is a potential risk.
The Indian e-commerce industry is still at a nascent stage and has much to learn and adopt in terms of legal matters relating to operations and consumer insights. Michael S. Mensilk, partner at Baker & McKinsey, offered a comparison of industry laws prevailing in European countries and the United States as points of reference for the Indian e-commerce industry to ponder upon.
Let me go back to the consumer protection rules just for a second, if I may, and sort of give you a bit of a picture of how this is approached in the EU versus how it is approached in the United States. And the rules in Europe were recently changed with a new directive. It's basically three areas: greater specificity around the information that has to be made available to the consumer, both pre-contract and after contract, changes to the so-called cooling off rules, and then some specific prohibited costs that cannot be now included. Pre-contract, okay, this is information that the site has to make available to the consumer before the consumer clicks I accept. There has to be a real big pay now or some other button that makes it clear before the consumer undertakes a financial obligation that he or she is about to undertake a financial obligation. It's got to be prominent. It's got to be conspicuous. If what is being supplied through the site is digital content, there has to be adequate, sufficient information about that content, what's required to use it, compatibility, and the like. There has to be a model withdrawal form that's tied to the right to cancel. There's a certain amount of basic information that absolutely has to be prominently displayed to the customer, including what is the total price, inclusive of that, for the particular item or the particular service or the particular content that the consumer is buying. And issues around contract renewal, if this is an ongoing service, contract renewal, minimum and duration, all of that has to be addressed, and it's got to be addressed, again, before the contract is formed. Once the contract is formed, The site has to be able to provide the consumer with the ability to basically keep a copy of the contract in durable medium. But in the United States, it comes down to 10 magic words in the Fair Trade Commission Act. The FTC, the Fair Trade Commission, can take administrative actions against any unfair or deceptive acts or practices in or affecting commerce. Okay? And you say, well, what unfair? What is an unfair act? Well, an unfair act, as you can see from the slide, is anything that A, causes injury or is likely to cause injury to a consumer, okay? So is likely to cause injury or actually injures the consumer, and B, is not reasonably avoidable by the consumer nor offset by some kind of countervailing benefit. And what does all that mean? Well, there's a whole line of cases that give meaning to those 10 words. And one of the most recent ones is what I refer to up there, the Wyndham case, where the FTC actually found Wyndham is a hotel hospitality chain, found Wyndham had engaged in unfair practices by failing to have adequate security in their IT and their online system. The passwords were too weak, the firewalls were too weak, there was insufficient use of encryption. So, I mean, imagine that. You've got the Consumer Protection Agency going after a company under these 10 words and finding that their security policies and practices are unfair to consumers and ordering them to beef those up. Security, obviously, is a big issue in the United States. It left me thinking, okay, what path will you take here in India? What path are you on? Are you likely to go the more normative approach that we have in the United States, particularly given how quickly the technology is changing, or is the more appropriate path for India, is it the more prescriptive EU approach?
The Confluence concluded with the felicitation of key e-commerce players by the legal fraternity. The Business Excellence Awards, recognizing innovation and excellence, was widely appreciated by the business fraternity, with Amazon India, Big Basket, Flipkart, Grofers, Ola Cabs, Snapdeal, Telexo and Zomato emerging as winners in different categories.
The e-commerce marketplace is getting more professional. E-commerce professionals not only want to know what are the legal issues that are impacting them, they also want to know the solutions, and those solutions that are not literally only legal, but a mix of commercial and legal.
This particular whole legal fraternity, the credit that it should get to get ECOM to where it is today, is not highlighted much. I am very, very thankful that this is a forum where they are sort of bringing the legal fraternity together and introducing them to the e-com players and giving them a platform where people are able to talk about issues which are impacting business, and also where legal fraternity can play a role.
We being from the legal fraternity, we've got a platform which has been provided by Legal Consulting to deal, to interact, to talk on personal basis with other people from the industry, like banks, like startups, like already established firms. So that's a key thing, that's a very important thing for us. And that's the one big takeaway for us from this conference, is that we get to interact with everyone from different parts of the industry.
I think it was really impressive to see how many people are so informed and want to have that discussion and want to be a part of the change and want to be in a position where India can actually take advantage of this huge opportunity, which is e-commerce.
Such a dialogue is really important because this gives a platform to the startups to interact, meet, learn, and take away the advice, the precious legal advice, as well as the policy advice for their business.
For success of any e-commerce company, the requirement of the domestic capital is, there is a need for a capital here, and there is not enough domestic capital available in our country. So we need a foreign capital inflow for our e-commerce sector to grow the way they want to grow here. Therefore, there is certainly a need to remove all ambiguities from any inflow of FDI into this sector here.